of the elements of the act involves it involves Nigeria. So the case has been brought before a Nigerian court. So if we're applying lex for it simply means that the laws that will be applied to that particular case will be the laws of Nigeria. That is the law of the jurisdiction where the case or the matter was instituted. So lex loci delicti is the other aspect. So lex loci delicti is the law of the place where the tort occurred. This principle has traditionally been seen as a fair and predictable way to resolve tort disputes involving foreign elements, as it applies the law of the location where the wrongful act took place. So this simply means this is a situation where the law of where the act in particular took place. So for example, a matter has occurred involving in which the element involves two jurisdictions, and let's say the matter has been instituted in Nigeria. So Nigeria can decide to apply the law of where the tort occurred. So that is lex loci delicti. So in Nigerian law, the principle of lex loci delicti is also inherited from common law and provides legal certainty, as parties can reasonably expect that the law of the place where the injury occurred would govern the case. For example, in the case of there was a case Koiki and Magusin, the Court of Appeal affirmed the importance of lex loci delicti in resolving tort disputes. The court held that where a tortious act occurs outside Nigeria, the law of the place where the act was committed is applicable, even if the parties are Nigerian nationals. This decision aligns with the common law tradition of applying lex loci delicti as a means to ensure fairness and consistency in cross-border tort cases. So, from the definition of these two, we'll be able.
What did you call that Nigerian case?
Sir?
What is the name of that case?
Koiki versus Magnuson, sir.
You cited it?
Yes, sir. Is in we got it from Nigerian Weekly Law Report, sir. The proper citation is in the paper.
Okay, very good.
Yes, sir. Yes, sir. So, from the definition of the two concepts, we can see that there's definitely a conflict between lex fori and lex loci delicti, which was addressed in our paper. So there's a tension, and the tension between lex fori and lex loci delicti arises in Nigerian law when courts must decide, because the courts are now faced with dilemma to decide whether they should apply the domestic law, that is the lex fori of where the matter was instituted, or they should apply the law of the place where the particular act in question occurred. However, Nigerian courts, like their common law counterparts, have had to balance the need for legal certainty with the desire to achieve justice on a case-by-case basis. While lex loci delicti promotes predictability and fairness by applying the law where the tort occurred, lex fori also allows the court to adjudicate cases based on Nigerian law, which may reflect local public policy or the specific needs of the forum. So one major challenge in Nigerian law is determining when to apply lex fori versus lex loci delicti. This decision often hinges on public policy considerations, the convenience of applying Nigerian law, or whether the application of law would lead to an unjust result. So when a court is faced with this particular dilemma in Nigeria, so there are certain factors that govern how the decision can be taken, which is the convenience on applying Nigerian law. How convenient is it to apply Nigerian law? If it is convenient to apply Nigerian law over foreign law, then they will tilt towards applying Nigerian law, or whether the application of foreign law would lead to an unjust result, because we all know the essence of the court is to promote justice and fairness. But if applying a foreign law would not promote fairness in deciding on a particular matter, then if it would be fair to apply the Nigerian law, then the court can apply the Nigerian law. So there's also a case we started there, Alhaji Olufumi Bakare versus Nigerian Railway Corporation, where the Supreme Court had to decide whether to apply lex fori or lex loci delicti in a case involving injuries sustained in a foreign jurisdiction. In this case, the court ultimately applied Nigeria law due to the strong connection of the parties to Nigeria and the public policy implications. Public policy is also a very important consideration when applying certain laws. If a foreign law does not if it does not sync with the policy in a particular country, then there's no need for the country to apply such law if it is against the public policy. So in Nigeria, there has been a growing trend towards a more flexible approach where courts consider
I'm not hearing you again. Oh. Hello?
Hello, sir. Yes, sir, I'm here. Depending on the circumstances of the case. So this approach recognizes that a rigid application of either principle may not always result in justice, particularly in cases where the foreign law may be contrary to Nigerian values or may result in hardship for the parties. So that we're able to deal with the conflict in this part. So we moved on to the evolution of choice of law in common law. So we spoke about the common law courts in England, how they face significant challenges also in determining the appropriate law to apply in tort cases with foreign elements. In the early stages, courts generally applied the law of the forum, that's lex fori, without much consideration to the law of the place where the tort occurred. This approach was based on the principle of territoriality, where the law of the court, that is, the law of the country in which the court is situated, governed the dispute. However, this created inconsistencies, especially when dealing with torts that occurred outside the jurisdiction. So over time, the doctrine of lex loci delicti, which applies to the law of the place where the tort was committed, began to gain acceptance in common law jurisdiction. So in this part, we're just explaining the evolution of choice of law. So then at this point there was a shift, and it was evident in the landmark case of Phillips versus R, which established that for a foreign tort to be actionable in English courts, it had to be actionable both under English law and the law of the place where the tort occurred. So this case laid the foundation for the double liability or double actionability rule in common law tort cases involving foreign elements. So the double liability rule simply means for a particular law to be applied, it must be able to apply to the lex fori and the lex loci delicti, that is, where the tort occurred and where the case has been instituted, the jurisdiction where the case has been instituted. That's the meaning of double liability or double actionability rule. So the former governor of Jamaica was sued in England. So we just laid a foundation as to the particular case that was cited earlier. Then we spoke about the actionability in forum jurisdictions. So the principle is that the alleged act must be of a character that would have been actionable if committed within the forum jurisdiction. So for the law of the lex fori to be, or the law of the lex loci delicti to apply in the lex fori, the act must also be that would be actionable if committed within the forum jurisdiction. So we also explained the double liability principle at large. That's chapter 3, paragraph 2. We explained that the double liability principle is one of the most significant developments in common law regarding the choice of law in tort cases. The principle was solidified in the case of Boyce and Chaplin, where the House of Lords confirmed the requirement of double actionability. The rationale behind this principle was to ensure that courts do not adjudicate cases that might impose liabilities inconsistent with foreign laws or infringe on the sovereignty of other jurisdictions. By requiring that the tort be actionable under both legal systems, the court aimed to strike a balance between respecting the laws of other countries and ensuring fairness to the parties involved. So this simply explains the rationale behind double actionability, which is to promote fairness, that the laws of other countries and the law of the particular country where the matter was instituted should be considered. However, the double liability principle has been subject to criticisms for its rigidity and complexity. It often led to unjust outcomes where a tortious act might be actionable in one jurisdiction but not in another, leading to conflicting results. In response to these challenges, modern common law jurisdictions began to adopt more flexible approaches. So in recent years, common law jurisdiction moved away from the strict application of the double liability rule towards more flexible approaches to the choice of law in tort cases. The Private International Law Miscellaneous Provisions Act 1995 in the United Kingdom marked a significant departure from the traditional double liability or double actionability rule. Under this act, the general rule is that the law applicable to a tort is the law of the place where the events constituting the tort occur, that's the lex loci delicti. However, it will be subject to exceptions where justice requires the application of another law. So also in the case of Red Sea Insurance Company Limited and Boyegs, the Privy Council emphasized that courts could displace the lex loci delicti rule if the circumstances warranted applying a different legal system, such as where the tort has a closer connection to another jurisdiction. This modern approach reflects a more nuanced consideration of the facts and the interests of the parties involved, which also allows courts to achieve fairer outcomes in cross-border tort cases. While the United Kingdom and other common law jurisdictions have embraced these reforms, the principle of lex loci delicti remains central in determining the law applicable to torts. However, courts now have greater discretion to apply a more appropriate system when the circumstances justify it. So what we have been able to explain is we have been able to try to balance choice of law when it comes to lex fori and lex loci delicti. We identify the conflict between the two concepts and how courts have tried to balance it in the common law jurisdiction and in Nigeria. So our part 4, which is the Nigerian approach to conflict of laws, will be taken by my colleague Alexandra.
Okay. Hello, Prof. Good evening, sir. Good evening, colleagues. I'll take the interstate and international dimension of torts in the conflict of laws now. So we talk about the fact that in tort cases with an interstate or international dimension, the courts are obliged to adopt approaches that ensure balance in the choice of law, taking into consideration the interest of the different jurisdictions, traditional and modern choice of law rules, and the closest and most appropriate legal system to the matter. The international and interstate dimensions in conflict of law on torts deal with determining the choice of law when torts occur across multiple jurisdictions. The pragmatic approach in determining the choice of law rules in conflict of tort cases was to apply the laws of the lex loci delicti, which my colleague just spoke on, rather than the lex fori, to ensure certainty and predictability, as from the case of Phillips versus R. However, this mechanical application of the lex loci delicti as the choice of law to the very nature of torts unquestionably led to injustices and harshness. So our paper examines the theories put forward for the applicable choice of law in conflict of torts law at the interstate and international level. So we move on to say that it is a settled principle of English law that the validity of contracts is governed by the proper law, which is the law as the parties intend it to be. However, this principle has been adopted or was adopted into the conflict of torts law by Morris for its flexibility in allowing proper weight to be attributed to the factors of constantly varying significance, such as the place of contract, place of performance, etc. In proposing a proper law of tort, Morris stated that it would promote a more rational approach to the interstate problem than the lex loci delicti principle. The adoption of proper law of tort rule is the application of the choice of law with a policy ground which seems to have the most significant connection with the chain of acts and consequences in the particular situation. So rather than following the strict double liability rule, which leads to hardship, which most times would work against a defendant, and which in situations, for instance, where a tort may occur in one place, but the consequence would manifest in another jurisdiction, such as in cases of air crashes, train accidents, and unplanned situations like that. This most significant test, closest relationship, as Morris adduced, would help in ensuring that the defendant would at least get justice. So a further advantage of the proper law of tort would be that it would allow problems to be broken down into smaller groups to facilitate a more adequate analysis of the social factors involved. For example, can a wife sue her husband in tort? We move on to the fact that because the law of tort is disparate in its content, unlike contract, the use of the lex loci delicti accords with legitimate expectations of the parties. The tort attaches certain liabilities to certain conducts and the creation of certain social risk. And then we consider the saying, when in Rome, do as the Romans do. Now, the double liability rule is preferred because of the certainty and the flexibility, the certainty it provides, rather. However, arguments against this mechanical approach could be difficult to determine. For instance, like I said earlier, where there's an accident in one place and the consequences manifest in another jurisdiction. So I'll move on to the interstate dimension. Now, torts are a residual matter, but due to adopted English law in Nigeria, the courts need not bother with the connecting factors as states have similar laws. In states with serious internal conflicts, to arrive at the applicable law, but when laws are the same, the judges shouldn't create conflict by shutting out the parties. I believe this is what Professor Olaniyan refers to as a false conflict. That's the creation of a false conflict, creating a conflict where there should be no conflict. And in this regard, we can refer to the case of Anamumbu versus Okafo. So we state that in conflict, it's the duty of the party who wants to benefit to prove and to plead his case. However, the courts are also obliged to take judicial notice of laws that are similar to theirs. And that was established in the case of Benson versus Ashiru, I believe. Yep. So also, we go on to state that for any court to insist on the strict application of the lex fori or the lex loci delicti, and here we're talking specifically about Nigeria, where our legislations are similar across state lines, that would lead to capricious injustice. And Dicey went on to say that it would be contrary to the moral principle upheld by English law to give damages for an action innocent under reason of foreign law. The principle for the body of rules known as conflict of laws is to secure at least a measure of uniformity in judicial settlement of disputes, no matter where they are litigated. The court of the forum will not adopt any legal principle of an outside jurisdiction which conflicts with the public policy of the forum. The court considers facts of the case not in naked isolation, but with their full juristic significance in light of the lex loci delicti, and then inquires whether a similar kind of liability exists under the lex fori. I hope I've given a quick summary of the interstate and international dimension. I'll hand over to Mr. Sebastian now.
Only two of you are exchanging between yourselves. What of the other two?
Mr. Sebastian is the third person, sir.
Oh, okay.
Good evening, Prof. So the earlier speakers have spoken on the interstate dimension. So I would only just give a brief and then give a conclusion. For the interstate dimension, we stated that for the purpose of conflict of law, it has been established that a constituent in a federal system of government is treated as a country. More so is the fact that the conflict of law seeks to resolve three questions that are all within the legislative competence of the states within the federation. These questions, as earlier stated, includes the choice of jurisdiction, the choice of law, and the recognition and enforcement of judgments. We also spoke about the uniformity of internal laws within the federation, which the earlier speaker has also spoken about. We also stated that it's important that these questions are resolved because the uniformity of decisions with states of the federation is not guaranteed by identical internal laws of the state alone, where the conflict rules of the state differ. We also stated that uniformity of decisions with states of the federation is also not guaranteed if the choice of jurisdiction rules differ. Furthermore, we also stated that uniformity of decisions with states of the federation is not guaranteed if the choice of recognition of enforcement of judgment differ. So it's important that the court seeks to resolve these issues, even if there's a cause of similarity in the laws of the federation. So we look at the uniformities of laws in the Federal Republic of Nigeria, which the earlier speaker have also stated that it poses a no conflict principle. And we concluded by saying that if since it poses a no conflict principle, we came up with a conclusion. I'm coming, sir. That it is also safe to assume that the interstate conflict of law are similar in Nigeria jurisprudence. Therefore, the following rules can be concluded at that the forum law is the same as the law of sister states where the tort occurred. The burden of disproving the earlier stated lies on the party who alleged the contrary. To discharge this burden, the party who so alleged should at least plead the sister state law he has in mind and then convince the court that by the choice of law rules, the sister state law is applicable. We also made critiques of some of the Nigerian case law that has misconstrued the principle established in Phillips and Ayres to determine a choice of jurisdiction as opposed to choice of law that the principle seeks to address. We made comments as to the case of Aman Nambu versus Okafo. We also made comments as to in the case of Benson and others and Ashiru and other Nigerian cases which we stated in our paper. So this is the crux of our paper, sir, and the conclusion that we have, sir.
Very well. Very well. And we have comments. Have you distributed that paper to the new class?
Yes, sir. It's on the group chat, sir.
Yes, comments. Or we should postpone postpone it to next week. This is an LL.M class. People should read seminar papers ahead of time so that they can have comments to make. Hello?
Hello,
We are
Prof.
with you, sir.
We are with you, sir.
We are with you, sir.
You are not with me. If you are with me, I said I am inviting comments on their paper. That paper has been submitted since last semester. I'm sure they didn't do any additional work on it. Okay, the presenters. You cited 2 Nigerian cases. 2 Nigerian cases were cited. Can you give us the facts of the cases? The first one, which was cited to say that Nigerian court will apply Lex Loci Delicti Commissi. What was the case? What were the facts of the case? Hello? Presenters. Hello?
Yes, yes, sir. I'm trying to locate the case, sir. I, I know the earlier presenter mentioned the case that you were interested in, sir. I don't know if that's the case you're talking about, sir.
Yes, that's the first one.
So are you talking about, sir,
There's
is it
another
the
case that
Anamubu
you
and
cited when
Okafor case?
No, not Amanambo and Okafor. Amanambo and Okafor was a case with really no direction because the court did not distinguish between jurisdiction and choice of law. Most of the Nigerian cases on tort, the court did not appreciate where jurisdiction stops and where choice of law stops. But the presenter mentioned a court of appeal case that they said they saw in the weekly law report.
Koiki versus Magnuson.
Yes, can you give us the full facts of that case and the actual holding? Did the court actually say that it is applying Lex Loci Delicti Commissi? Because Nigerian courts, hitherto, are fond of singing double liability while applying Lex Loci Delicti Commissi. So can you tell us the facts of that case? Everybody must go and read that case so that we will see whether the courts are beginning to depart from their comedy of errors when they will be talking about double liability, but in actual fact, they are treating double liability as a rule of jurisdiction, whereas it is a choice of law rule. So give us the facts of that case in summary, if you have it. If you still remember it. Where did the tort occur? Was it outside Nigeria or in one of Nigerian states? Hello? Was the case an interstate situation or an international situation? Give me the name of the case again. Let me see whether we can read it on Google. Hello? Hello? Hello?
Hello, sir. Hello,
Yes,
Prof.
yes.
Okay, the case is Koiki versus Magnuson. And the facts of the case states that a brief summary of the facts of the case states it had to do with the delivery of bills of goods. And So it states here that the High Court initially awarded the plaintiff special damages and general damages in the sum of 1 million naira, but the Court of Appeal reversed this decision, dismissing the plaintiff's claim. The plaintiff then appealed to the Supreme Court law. And okay, I believe somebody has sent the citation now. And it is, 1 second, sir.
I'm not hearing you again, no. This virtual lecture is not working. I think as from next week, we will be doing physical lectures. Hello?
We can hear you, sir.
You see, the fact of the case that she's giving us is not relevant to our own something. Before, they said that the court said they will apply lex loci delicti commissi. So we will need to read the case and see whether it's a case of interest to us in this subject area. I would have loved to know whether the accident occurred in one place or whether the thought occurred in one place and action was visited in another, which we warrant applying a choice of law rule or what? That the High Court gave a judgment, the Court of Appeal overruled it. That's what happens now. That's not our interest. But they cited that case to say that the court held that the law of the place of the thought applies. If it is true, then it will mean that that case is different from all the other cases that our courts have been deciding. Because in all the other cases, the courts have been using double ability, treating it as a jurisdictional rule to decide the case, whether it's Amanabo and Okafor or Benzi and Dashiru or whatever. That's what they've been doing before. That's why I was interested in the case. Then they cited another case where they said the court was talking about convenience and justice and all of that, which, if it is true, that was, hello?
We can
If
hear
it
you,
is
sir.
true,
We can hear you, sir. We can hear you, sir.
if it is true, those two cases would deserve closer attention. What you are going to do for me, text the citation of those two cases. Okay, is it in your seminar?
Yes, sir.
Did you
I
cite the
will.
two cases in your seminar?
Yes, sir. It was cited, and we would also look further and furnish the class with facts of the case as well.
No, it's not furnishing the cards with the fact of the case. Let everybody go and read the two cases.
Noted, sir.
Did you get the two cases from a textbook or whatever? Hello? Did you
Yes,
get
sir,
the
my,
two cases?
yes, sir, from a text, sir. I believe my colleagues worked on that part of the seminar paper.
Oh, it's with Okoli and Opong. Did you get the two cases from Okoli and Opong? Nobody's answering me.
Sir, our colleagues worked on it, and they're no longer offering the course, so we are not sure as to where they got the cases from. But we would inquire, sir, and they furnish the class with the sources of the
Let
cases.
everybody go and find out was it true that the Nigerian court decided that Lex Loci Committee would apply? Was it true that the Nigerian court said alternatively it will apply forum law if application of the Lex Loci Committee will create injustice? To be very interesting to see whether Nigerian courts are already deciding like that. The previous cases, all of them seem to have ended in confusion because the court seem to have mixed choice of law issue with choice of jurisdiction. Okay? Then for a discussion on thought, this your seminar paper is grossly inadequate because we used to break thoughts into three parts. We look at the different connecting factors, the advantage and disadvantage, Lex Ori, Lex Loci Committee. Each of them has its own advantage and its own disadvantage. Then we look at the different tests that have been applied. I saw that you attempted to do that. You look at proper law of the thought. But proper law of the thought is not the only test that has been applied. We have government interest analysis. We have Carver's principle of preference. We have basic Lex Ori. We have American second restatement of conflict of laws, and so on and so forth. Professor Agbede in his book discussed those options under the topic new basis for solution. Then you have to discuss the Nigerian position. What is the Nigerian position? In the past, the courts are fond of saying that they are applying double ability. Okay? Citing Australian and English cases for their position. For example, Bessie and Nashiru, they said they were applying double ability, citing Australian case of Coop and Beb. So we need to know what is the meaning of double ability. What is the meaning of double ability? And you can't know the meaning of double ability until you explain the fact and the decision of Phillips and Air. Okay? What does it mean? What does double liability mean? It simply means that the court cannot determine liability for tort unless the conduct complained about is also a tort in the forum court. Then in addition, the conduct complained of must not be justifiable in the place where it was done. Okay? But it is a choice of law rule, not a choice of jurisdiction rule. Because the common law basis of jurisdiction does not emphasize where an event occurred. It only emphasizes where the defendant is served with the writ. So, by the common law basis of jurisdiction, you can sue a person in Nigeria in respect of a tort that did not occur in Nigeria. There may be no other connection with Nigeria other than that Nigeria is the place where you obtain the writ and you are able to serve it. So that is the distinction between jurisdiction and choice of law. But you often find that Nigerian decisions just confuse everyone by not appreciating the distinction between jurisdiction and choice of law. Many of the tort cases, they end up on the question of jurisdiction, which ought not to be so. Okay? So I expect a sound write-up to look at the Nigerian cases on the matter and analyze them. The problem with the Nigerian cases is that the courts will be talking about double liability, but in actual fact, what they will apply is lex loci delicti commissi. That's what they apply. They assume that you don't even need to prove it, that it is the lex loci delicti commissi that applies. So they will treat the double liability as a choice of jurisdiction rule, whereas they will say they are relying on English law. And the English law treats double liability as a choice of law rule. That's why I said I will be interested in those new cases cited. Let us see whether they departed from the confusing approach that most of the Nigerian cases, there are quite a number of cases on the matter that Nigerian courts have decided, but they have not been clear whether they are applying double liability as a choice of law rule or as a choice of jurisdiction rule. And that's why those two new cases you are citing might just be a movement forward. They are not cases to be glossed over if they actually decided what you said they decided. Okay? Then the international and interstate dimension, what are the issues there? Choice of law rule is the same, both for international and interstate. The only thing is that conflict in the interstate level is usually force or no conflict. What do we mean by that? If an accident occurs in Sokoto and an action is instituted in Lagos, why should we bother ourselves about which law to apply when Sokoto and Lagos law are the same common law? But you will find Nigerian court deciding the matter. You will find a Lagos court throwing the case away and saying you should go to Sokoto. And they will say they are applying they will link it up with double ability, or you find a Lagos court applying Lagos law, rely on Phillips and Air. Not that it is not correct, but what Phillips and Air said is that the forum law will apply insofar as you cannot show a difference between it and the locus delicti. So it becomes clear when the court explains it like that. On the other hand, on the few occasions when the Lex Loci Delicti Committee was different from the Lex Forai, you see the court belaboring the point, which means that what they had in mind to apply is the Lex Loci Delicti Committee. They are just singing about Lex Forai. So what I will do is I will, all of us will go and look at those two cases and see whether they departed from the crowd of cases. Itato decided on the double ability issue. Yetunde, did you deliver the letter?
Yes, I'll take that.
Okay. So let us go and read the seminar paper and see whether, I think I will talk about, I would give more, some 20, 30 minutes talk after I've seen the two cases they cited. Then go and read Agbede's themes on conflict of laws, especially I think he has 2 chapters on thought. He has 1 chapter where he's looking at new basis of solution. Then he has another one where he's looking at how Nigerian courts have applied double ability. Okay? Then I'm sure these people, I gave them an article of mine, incidentally, which I never published, on conflict of thought laws. I will send that article to your platform. Everybody go through it and go through there are 2 cases so that we can have a 30 minutes discussion before we move to another topic. So what is the next seminar paper? What is the title of the next seminar paper? Hello?
Yes, our product
Hello,
liability in conflict of laws.
Okay, we can take product liability in conflict of laws next week after I have discussed this one. Okay?
Okay, sir.
Okay, sir.
So I'll see you next week. And next week is
Okay,
a
sir.
very
Thank you,
busy
sir.
week for us. The lecture is going to be physical, please.
Okay, sir.
Yes, Prof.
Thank you, sir. Please, if you've not dropped your name, kindly do that, your attendance, and take a screenshot, please. Thank you.